Welcome. Thank you all for coming. My name is Bob Redmond. I'm the chair of the Social Justice Pro Bono Committee, which was just formed by the board this past year in 2015. We had a kickoff meeting yesterday. I think most of you all were there. I think that went reasonably well, and we had some good enthusiasm at the end of the talk. This is, as I indicated at the talk yesterday, this is a little more nuts and bolts, and this is part of our initial program. In still forming the committee, one of the things we decided collectively was that our membership is more inclined to respond to specific hands-on legal problems rather than kind of more general social justice, advocacy type of issues. And so in terms of kicking off with an initial program, we collectively decided we would offer to the membership the opportunity to learn immigration law, to allow them to take on immigration cases and appear in immigration court, to provide some measure of status to the extent it's available for people who enter the country without inspection. This is, as I indicated, a much more nuts and bolts type of presentation. There are materials that are in your CLE materials. I'm going to be working from them. If you don't have them, I'm going to try to describe the paperwork that you're seeing, because I think to really get the full impact of how to, the nuts and bolts of presenting these cases, it's important to see the documents. If at any time you need me to explain it, let me know. We got a nice small group here that we can interact pretty well. So with that, let me give you a little bit more background. I talked a little bit about this at the meeting yesterday, but in March 2005, I was and I'm still doing mass tort litigation, but we decided that we would offer our team, our resources, and our experience in the form of a pro bono clinic. We selected the Hispanic immigrant community in Richmond as kind of the focus of our efforts, and connected with the Virginia Hispanic Chamber of Commerce to start a program which we kicked off in March 2005. That program is still going strong. There's actually 2 nights per month. There's an intake session for Latino immigrants, and that's thriving reasonably well. The 2 general areas that we found were needed in the community were unpaid wage claims and immigration. The unpaid wage claims were pretty straightforward contract and labor and employment claims, which seemed to suit well with the younger lawyers that were attending the clinic, and that has really continued to do well, and we've been able to collect. I didn't mention this in the meeting yesterday, but we collected over, I think I stopped counting when we hit $350,000, and that was about 2010. I think we've probably collected over $500,000 in unpaid wage claims, and that's, I think, that tends to generate a lot of gratitude in the client community, so that's been good. In terms of immigration law, that's a much tougher row to hoe, so to speak, in terms of getting a solid win that you can say, I got that person status or citizenship, because a lot of the laws and regulations tend to be obstacles rather than helps in that regard. But there is a path to giving these clients relief, and that's what I'm going to talk about today. So the people we're focusing on are, probably in the media they're known as illegal immigrants. The technical term is EWI or EWI, entered without inspection. That's your classic situation of somebody coming across the southern border, either getting apprehended or not apprehended, and getting apprehended later. There are generally forms of relief that are applicable to all these border crossers, as far as I'm concerned. And these include asylum, Convention Against Torture, and withholding of removal. And it's important, I found this out the hard way, it's important to seek all 3 forms of relief in the initial hearing. So basically, like a lot of legal proceedings, you have an initial appearance where you plead your forms of relief. And it is standard procedure to ask for all 3. And in fact, if you ever go to immigration court, at initial hearing, the judge will say, what forms of relief are you seeking? And the experienced lawyers will say, asylum, CAT, withholding. Boom, that's all it is. And those 3 forms, they're related in a lot of ways, but they're significantly different in their statutory sources. The facts generally support all 3. If you have the typical set of facts, you're going to be able to at least seek all three, and that's what we're going to talk about. A couple key issues, and this, people run afoul of this often, especially back in the day where there was not as much border enforcement. So what you would have is someone who would cross the border and wouldn't be apprehended. They would come across the border. They might live and work in a community for 3, 4, 5, 6 years, and then they get caught at a traffic stop, or they get caught in a raid or something like that. At that point, it's much harder to seek these forms of relief, especially asylum, because there's a 1-year requirement for asylum. Fortunately, for kind of the modern set of cases, minors have 1 year from the date of majority. So they are not, it's kind of like a statute of limitations. Once they reach majority, then the 1 year starts. But if they come in when they're 16 and they don't get apprehended until they're 18, they still have a year. So that's another thing to look at in terms of nuts and bolts. Look at the age of your client and the date that they came across. This is the elements of asylum. This is from 8 U.S.C. 1158. And the key language here is, if I can spot like this, refugee, the definition of a refugee. This is, I should have said this at the outset, immigration work is basically statutory interpretation and applying statutory interpretation to the forms of relief. There's very little common law, so to speak, in immigration matters. There are some recent Supreme Court and Circuit Court cases that kind of set limits, but it's not the type of thing like contract law where there's a whole body of common law. It's all pretty much based on the statute. And this is the key statute right here. The burden of proof is on an applicant to establish that the applicant is a refugee within the meaning of this section, 8 U.S.C. 1101, H42A. To establish that the applicant is a refugee within the meaning of such section, the applicant must establish that the race, religion, nationality, membership in a particular social group, or political opinion was or will be at least one central reason for persecuting the applicant. And that is a meaty sentence that really has, in many ways, all of the key issues pushed into one long sentence. So you have to establish that race, religion, nationality, membership in a particular social group or political opinion was or will be at least one central reason. Membership in the social group is kind of the way that's compressed in terms of arguing the case to a judge. You need to establish that your client was a member of a particular identified social group that is subject to persecution. One of the things that I've advocated for, not successfully, frankly, but this part of the statute that says at least one central reason. It's not the only reason, because I think when you dig into the case law, especially the circuit court case law, you'll find that they tend to say it has to be the only reason. In other words, if the classic example is you've got a Latino teenager. He's from El Salvador, or Guatemala, or Honduras, or one of the Central American cities, and he's being pressured to join one of the two major gangs in that area, 18 or MS-13. And basically, what I've found in my cases is that in many of the towns, small, medium, even large towns, the towns are divided into groups, and you either are in one or the other, and there's no in between. And what a lot of kids try to do is they try to basically finesse the membership in the gang. They don't join a gang, but they kind of say, I'm thinking about it, because it's almost formalized now, as I understand it, that by the time you're 18, you need to be in a gang. So, and you have about 5 years of run-up, or kind of interviewing, for lack of a better analogy. When the kids turn 13, they start to get pressured to join one gang or the other. As they get about 16, if they still haven't joined a gang, they get a lot of pressure. And when I mean pressure, like beatings, shootings, people will, I had a client who had a gun put next to his head and fired when he was 16 and said, you've got one more chance. And that kind of pressure leads these kids to cross the border. They come north and they try to find usually a family member. What I've found is that there's typically one of the two parents or a brother or sister who's been in the country for a while, and they try to reunite with that person, and then kind of get into the community that way.
Is the gang membership equally true of women as well as males?
Not as much. Unfortunately, it's frankly even worse. It's you can be a member of the gang, but you're kind of like, I don't want to say gun moll, but it's not, you're basically, I wouldn't say a prostitute, but you're there to service the men of the group. And as I understand it, they don't really have the life or death choice. You can join or you can be pressured to join, but it's not, if you turn 18 and you're a female, you don't face a death penalty if you haven't joined a gang. Right, exactly. So getting back to the membership in a particular social group, there's a fair amount of case law. In fact, probably the majority view is that being pressured to join a gang does not meet these qualifications, a particular social group. So, lawyers being kind of inventive, they have what you need to do is you try to find some slice of the pie that gets you into a particular social group. There's a great Fourth Circuit case that says, basically the client was not, he wasn't saying I was being forced into a gang. He was saying, I'm in a particular social group of people who report pressure on gang membership to the police, and the police don't do anything, and therefore I was persecuted because I talked to the police, not because I refused to join a gang. And the Fourth Circuit actually gave that form of relief some credence. So it's important to try to be as inventive as you can for that. As I mentioned before, I've advocated that pressure in a gang membership doesn't have to be the only reason for persecution, but it needs to be one central reason. I think there's some headway to be made there as well. Further definition of a refugee. A refugee means any person who is outside any country of such person's nationality, i.e. Honduran in the United States, who is unable or unwilling to return and is unable or unwilling to avail himself of the protection of that country because of persecution or well-founded fear of persecution because of race, religion, nationality, membership, or particular social group or political opinion. So again, unwilling to avail himself of the protection of the country. That is, they don't want to go to the police in Honduras because the police will tell the gangs and the gangs will kill that person. That is a source of relief that you can get under this definition of asylum. This is Convention Against Torture. This is a separate form of relief, and we talked about that at the beginning. And this is from the Fourth Circuit case. Unlike asylum and withholding of removal claims, which require an applicant's fear of persecution to be based on an enumerated ground of protection, under the CAT is available for an applicant who can prove likelihood of torture regardless of motivation. So one of the benefits of CAT is that you don't have to prove this particular social group. What you have to do to go back is to prove that you're unwilling to avail yourself of the protection of that country because of a persecution or well-founded fear of persecution. So keep that in mind for CAT. If you've got a problem with a particular social group, CAT may be a good avenue. In these cases, they tend to, as I said at the outset, you ask for all three forms of relief: asylum, withholding, CAT. And in these circuit court cases, they tend to focus on asylum and brush off the withholding and CAT claims. It's worth looking into a couple of these opinions. Lizama is a great opinion because they talk more about CAT. And I do think in terms of mechanics of advocating, I think if you start pushing CAT more, you may be more successful.
Would that include female forced into prostitution?
Yes, I think it would. Because there's really good law that torture is not necessarily, thumb screws and whippings, that sort of thing. It includes mental abuse, and so that would be a form of relief as well. Torture really arises from, the CAT, the Convention Against Torture, arises from the United Nations, one of the treaties, I forgot which one, but that's really the source of that law. Here's the definition of torture: any act in which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person when such pain or suffering is inflicted by or at the instigation or with the consent or acquiescence of a public official. The key in CAT is that you have to have a connection to a public official. So a route of success for these iwi claims with Central American and Latin American clients is you get the acquiescence, focus on the acquiescence, because there's a pretty good body of factual development that you can show that the public officials, the judges, and the police in some of these countries basically cede power to the gangs, and that there are sections of the country that are run by the gangs, and the public officials are basically puppets. That's how you get CAT for your Central American iwi. A public official, and this is really key as well, because stepping back a minute, the body of case law, especially at the circuit court and the Supreme Court level, has been very resistant to the idea that Central American and Mexican and Latin American refugees can qualify for these forms of relief. And I think, frankly, it's probably less based on a legal analysis and more based on kind of this visceral fear of the other crossing the border. I think that's really what's driving it. And ironically, some of the justices who have immigrant roots are the ones who advocate that the most. But in any event, the determination of whether a public official acquiesces is really key. Here's what the Fourth Circuit said fairly recently. A public official acquiesces to torture if, prior to the activity constituting torture, that is, death threats from a gang, the public official has awareness of such activity and thereafter breaches his or her legal responsibility to intervene and prevent such activity. This, frankly, I think this sentence absolutely captures the situation in many Central American countries, especially in the smaller towns, where you have these gangs dominate, and I mean literally dominate the town. I had a case where a client of mine lived in I'd say a medium-sized town in El Salvador, and we were able to get newspaper articles that talked about how the gangs had a tax on presence in the center of the city. And I mean, they would come up to you, and if you were there walking through the center of town, they would ask if you've got proof that you paid the daily tax. The daily tax was like $4 a day. And if you didn't have a stamp from the gang that you paid your tax, you'd get either robbed or beaten or worse. And that, as far as I can tell, that is a legitimate exercise of sovereign authority by these gangs in the center of town. And of course, the public officials, the nominal public officials, knew about it and allowed it to happen. So I think, again, that's something to really delve into, especially if you have a client and they're from these Central American towns. Ask them to describe in detail who runs the town and how the town is divided. I was able to get a map, and my client was able to kind of demarcate who owns which side and where he lived. He lived, of course, right smack in the middle, so he was getting hit from both sides. Withholding of removal. This is 8 U.S.C. 1231. In general, notwithstanding paragraphs 1 and 2, the Attorney General may not remove an alien to a country if the Attorney General decides that the alien's life or freedom would be threatened in that country because of the alien's race, religion, nationality membership in a particular social group or political opinion. This, again, those adjectives there, or nouns, are the language you saw in Asylum. The issue with withholding is that it doesn't lead to citizenship as asylum does. Asylum, if you're a successful asylum applicant, you will get a green card, and then after 3 or 5 years, you can apply for citizenship. Withholding doesn't give you that. I think it gives you a green card, but it doesn't give you more than that. And this is kind of where it says if the Attorney General decides, that's the immigration judge. So again, I didn't talk about this, but the Department of Justice runs the prosecutorial function in immigration proceeding and also the judicial function. And I think, frankly, they do a reasonably good job of demarcating the line between prosecutor and judge. It kind of reminds me when I was in the Army as a JAG, and that's the same thing. The Army employs the judge and employs the prosecutor. But I think, in fairness, they do a pretty good job of demarcating the line. I do think that there are immigration judges who have ambition, who decide it's probably better for their career to tend to be harder on immigrants than that. But I also know judges who, basically want to do the right thing and are willing to rule against the government on a case-by-case basis. And this is really the thrust of it, they'll rule against the government if the case is made. The problem with a lot of these immigration cases, probably most of them, is the case is never made. And to make the case, you have to be an attorney. I think the statistics are clear that immigrants with attorneys do much, much better, like on an order of magnitude of 8 to 10. That, in other words, 80% of immigrants who have attorneys get some form of relief. Probably less than 10% of immigrants without attorneys get some form of relief. It's just that stark. And that's the reason I think the Social Justice Committee thought this might be a good case or project to kick off on, because I think you will have a remarkable effect, number one. And we'll talk about this at the end. But frankly, the whole immigration justice system suffers from a lack of quality in the defense bar, so to speak. And it's unfortunate, but the paid immigration bar, and I'm not disparaging them, but the remuneration is so low, and the clients there's so many clients, it's just really, really hard to do a good job. It's a little bit analogous to criminal defense, I think, but that's just how it is. And I think if you can have an infusion of pro bono attorneys who have skills as advocates, you can raise the bar across the board. And frankly, the judges, I think, recognize this. The immigration judges that I know are very, very grateful when a pro bono attorney from a firm of substance or who has experience appears in court and attends. They're very grateful for that because, frankly, they want the system to work fairly as well. But if they have 100 cases to get through, an initial call, and only 20 of them are represented, it's just tough. And they've got to get through their docket. And if the person shows up with an attorney, they go through the drill of telling them that they got to get an attorney and giving them a pink sheet that tells where the pro bono attorneys are. And 9 times out of 10, they show up at the next hearing, they don't have an attorney, and then they get deported. That's just how it works. But if you have an attorney, then you can go through the steps I'm going to illustrate in a minute to give these people some form of relief.
What percentage of the cases that y'all took in were you successful in?
Successful is a relative word. I will say this: I have probably in 200 cases, I only had one family broken up, and that was really, really terrible. I'll tell a quick anecdote about it. I'll tell that story. It's a terrible story, but it kept me motivated. It was a family, a wife, husband, 2 kids. The husband had a form of lawful status called TPS, or temporary protected status. In the 90s, early 2000s, Salvadoran immigrants had an opportunity to get a form of relief called TPS. It gave them a social security number. It didn't give them a green card, but they had a work permit, and they could renew it year to year. And TPS was a way these folks could live relatively openly. It was renewed on an annual basis, but it gave some form of relief. Well, the husband sent for the wife, of course. She came up. The wife sent for the 2 kids. It was an 8-year-old girl and a 6-year-old boy. The wife made it. The kids got stopped at the border. The family was able to pick up the 2 kids, but the government called them in. They had a notice to appear. They had to appear at the hearing. We tried to get them some form of relief. It was denied. We ended up having another form of relief called prosecutorial discretion, which I'll talk about. That was denied. And so at this hearing, these kids got an order for deportation. They were 8 and 6, and they walked out of the hearing knowing that they were leaving their parents and go back to El Salvador and live with their grandmother. And they were crying and screaming, and it was yelling. It was really god-awful. It was terrible. And the worst part was that the younger girl started pointing at me, and she thought I was at fault. It was just awful. But that was probably the worst. Most of the time, I was able to get prosecutorial discretion or kick the can down the road. We were fortunate in that a lot of the clients that I had were adult children of parents that had brought them as smaller children. DACA standing for I keep forgetting what DACA stands for, but it's basically kids that came to the country when they were little by their parents and then grew up in this country. Obama had basically put a halt to their deportation and they have some form of relief. That's taken a lot. I had a lot of clients like that. I've had a lot of clients I've gotten prosecutorial discretion for, where we were able to convince the government that it's not worth the resources to deport this person because they have no criminal history, they've got U.S. citizen children in the country, and so basically the government just lays off. But that's, I probably had 4 and maybe 6 people deported, and probably another 10 that went out on what's called voluntary departure, or VD. Voluntary departure is a form of relief that basically, I'd call it like a plea bargain. The alien agrees to leave within 120 days, and the government agrees not to find them as being deported. So in other words, they can try again to get into the country lawfully, and they won't have the black mark on their record of a prior deportation. So VD, I probably had another 10 to 15 clients that we got VD for. Okay, I told you this is nuts and bolts. This is nuts and bolts. So when you have an asylum applicant, you've got a form, I-589. In this form, there's a box you have to check for CAT. Always check that box. When you get a client, you're going to get, the first thing you get a notice to appear. It's going to have the client's name, and it's going to have an A number. A is kind of the main control number for that client. So it's going to say A hyphen, and it'll be, I think, an 8-digit number. Make sure you put that on your file. You've got current address, mailing address, usually the same thing. There's a box to check. Are they in immigration court proceedings? Almost always are. If they come to you as a pro bono lawyer, they're going to be in immigration proceedings. The only reason that box is on there is if the person gets across the, a lot of times what you get, and I have never gotten these cases, is you'll have a lawful admittee on a visa who, when they get to the country, they'll apply for asylum. And in that situation, they won't be in immigration proceedings. They'll be outside of immigration proceedings, but they're applying for asylum. The date, this is the status of an as I mentioned here, they ask for status. Status is EWI, entered without inspection. Others might be visa holder or something like that. But the date, a couple, again, nuts and bolts. The date the person left the country should precede the date that they arrived in the U.S., just as a rational matter. Often the client will not have a passport or will have been taken from them. They ask for passport numbers. Sometimes I've had clients that do have a Salvadoran or Guatemalan passport. You can put that in there. That's always helpful. The more identification, the better. This line, it's tough to read. It says, your spouse. I am not married. Skip to children. It's a lot easier if you have a client that's not married, because if they have children either in the country or out of the country, you just have a whole lot more information to put in. What I've found is that detailed information is hard to get from the clients because they, obviously they come to this country with mostly the clothes on their back. So if you start asking them what the street address in El Salvador is for their second child, it's complicated. This is the I-589 again. This is an important but difficult issue. You need to get all the addresses for the past 5 years that these folks live in. And the typical scenario is, especially if it's a teenage boy, they'll cross the border to get arrested. They'll go to McAllen, Texas for 30 days for processing. And then they'll go to Miami, Florida for a school for recent arrivals where they'll get screened, they'll be tested for English, they'll be given some medical care. And during that period, that's when they're trying to contact their cousin or mother or aunt or whoever it is they're contacting in the U.S. And it usually takes 30 to 45 days before that person is able to come down and pick them up. And then they'll move it to Charlottesville or Chicago or wherever, and they have to have all those addresses. If you have a client that's been in the country for a while, this can be very extensive and very difficult because you have to find out where they've lived, for the past 5 years. A lot of times they don't know. You can have your asylum application kicked back if you just have a blank or you have a skip in dates. And frankly, if they just try to fudge it and say, oh, I lived at this address for this period of time, during the asylum interview, that may come out, and then you've got a problem. Because making a false statement on an asylum application is a felony, and you don't want to be a part of that. Some of the other stuff. Again, they asked for, it's hard to read, I'll read it for you. Point 5, provide the following information of your parents, siblings, others. Check the box that applies. So if you have a big family, you've got to get all the information about the mother, father, siblings, where they live, where their current location is, and that takes time. That's a kind of a difficulty. Yeah, Matt.
So my understanding is once you properly file the asylum form, it could buy the client a year.
Oh, way more than that. Way more than that. Right now, they're in Arlington, Virginia, the Arlington Immigration Court. They're setting individual hearings out 3 years from now. So
we have a client that is insisting on applying for asylum. The facts are fairly thin, but that's what the client wants to do. So we're going to do that, and that will necessarily then put her in line for a couple more years, right? I mean, it's going to buy her a minimum of a couple years.
Oh, yes. Yeah. I mean, is she in proceedings already, or does she want to? She's not. She's out of the system, and she wants to jump in.
No, she's within the 1 year.
Okay.
She's about 3 months into 1 year.
But she was apprehended.
Yes.
Okay, so something's going to happen one way or the other. So either she doesn't apply for anything, and then she's going to get deported, or voluntarily depart, or she can take a run at asylum, and she'll have a hearing on that. We'll talk about this later, but if she's a minor, you can hopefully get the court case closed and have her asylum application resolved before an administrative officer. Asylum applications, if they're not in proceedings, they're done by basically a bureaucrat behind a desk, where they interview the person and determine whether they think the person meets the criterion for asylum. If that's denied, you still have the whole judicial process to go through. So something to keep in mind is that if your client is a minor, apply with the asylum office. If you lose that, you've got the whole court process to go through. So at that point, you can buy probably 5 years.
Are
Yes,
there
Ken?
immigration courts in every state? And are
No.
there some places where there are more than one per state?
No and no. There's usually, it's kind of a regional setup. In some places, like on the East Coast, they may be close in proximity. For example, Arlington is the immigration court for Virginia, West Virginia. Yeah, Virginia, West Virginia. Baltimore is probably 35 miles away. That's all of Maryland plus Delaware. And then you have Philly. You get out west and the south, Charlotte is the immigration court for North and South Carolina and Tennessee, or Eastern Tennessee, I think. And then Atlanta has one. I don't think there's one in Alabama or Mississippi. They may go to New Orleans. But I know that there, especially in the center of the country, it's hundreds and hundreds of miles to the immigration court. Again, this is all in the materials, so if you ever get a case, you pull up the materials, and this is going to be a lot more helpful. This is kind of the guts of or the substance of the application. There's initial questions that determine whether a person is even admissible as a potential applicant, and they're basically things like, are you a member of the Nazi Party, or have you engaged in terrorism? The answer to these questions should be no. Then there's questions of, do you fear harm if you're returned to your home country? And the answer should be yes. And then these are the questions that should be no. The facts that establish torture, usually you would put them in an addendum, like a lot of government forms. There's like a little box here, but you want to fill up more than that box. Additional information about your application. One of the questions is, have you or your spouse or your children or family members or your parents ever applied for asylum in this country? No. or actually, this is if you've traveled through here's the question is, have you stopped at any country before you came to the United States? Basically, the question is intended to focus on whether you've sought asylum in another country before you came to the States. The idea being, if you're really afraid of El Salvador and then you go to Guatemala, why didn't you apply for asylum in Guatemala? Well, because the problems are equally bad there. And then what about Mexico? Well, the problems are equally bad there. So you need to address that. A lot of people miss that in the application. You say, here, in this application I did, I said, I traveled through Guatemala and Mexico to reach the United States, and I did not apply for refugee status because my persecutors were close by. And that's an honest statement of the scenario that's out there. Are you filing this application more than 1 year after your last arrival in the United States? The answer is yes. I was an unaccompanied minor when I arrived. I mentioned about minority. They have to be unaccompanied. It has to be an unaccompanied minor to get that 1 year. Here's another nuts and bolts issue I found out the hard way. The asylum applicant needs to identify the person if someone helped them with the applicant. So you can put your name on that as well. If you get into this work, you can have non-lawyers prepare the application. That's perfectly appropriate. I've had a lot of paralegals prepare the application. And as long as they disclose that, then you're fine. Again, another nuts and bolts issue. There's a last page, Part F. Don't have your client sign that. I found that out the hard way. They have to sign that in the presence of either the court or the asylum officer. So in other words, the court swears them, has them say, it's kind of like a verification for an interrogatory answer. Have you read this? Do you understand it? Is this true and accurate to the best of your knowledge and belief? And then the applicant signs it in the presence of the judge or the asylum officer. So that's the nuts and bolts of an I-589. This is the addendum. This is the most important part because this is where you identify kind of the story. You tell the narrative that lays out all the elements of asylum, withholding, and CAT. And like any good argument, you need to establish the elements and establish the facts that support each of the elements. And it certainly helps if you can make it in a compelling narrative fashion. Like any summary judgment brief, it also helps if you have attachments and exhibits. One of the best exhibits, kind of a standard exhibit, is what's called the U.S. State Department Human Rights Country Reports. These are issued, I think, every couple years. This is the most recent. I believe this report was updated on March 2014. There might have been a more recent update. But it describes everything that I've talked about so far about the situation in El Salvador with the gangs and the corruption and the police and the judiciary ignoring the problem. Go back. It also helps to have newspaper articles, and here Google is invaluable. Yes, Matt?
So there's certainly going to be some countries that are going to be immediately recognizable as ones that are going to be sympathetic or supportive to the asylum audience.
Yes, yes. Well, I would put it this way. There are some countries that the judges will know that there's a case to be made that asylum and CAT are there. I mean, I think if you put in Canada or Sweden, you'd have a tough road to hoe. So El Salvador and Guatemala and Honduras, it's a little easier.
And aren't those countries much more notorious than Mexico is?
Oh, much more. I mean, I have, interestingly, I don't know whether it's just Redmond or the East Coast or what have you, but I haven't had that many cases with Mexican nationals. In fact, probably less than 10% of my clients are from Mexico, and I get overwhelmingly Guatemalans and Salvadorans. And I don't know if that's just because Virginia is kind of a mecca for Salvadorans. It's actually the largest Latino community, largest Latino group. The largest country group of Latinos in Virginia is Salvador. And then after that, it's Mexico, then it's Guatemala and Honduras. But yeah, I think that's the case. As I mentioned, Google is invaluable because it helps to get newspaper articles, and you can pull up current newspaper articles from El Salvador. There's a couple articles, and they have vivid descriptions of gang killings and taxes on citizens, and get those. Again, a technical tip, everything that you attach has to be in English. So you can have a Salvadoran article. It doesn't do you any good. It will be rejected by the court unless it has an English translation with it. The good news is, thank the Lord for Google, you can copy everything into Google Translate and then get a translation, print that out and attach it, and then all you have to do is certify that this is a translation obtained from Google. It has to be signed under oath by a notary, but it's, you can do that. My paralegals would be the translator representatives, and they would certify it. So, again, a nuts and bolts issue.
If,
Yeah.
in terms of dealing with your clients, are there any translation resources?
Yeah, what I found is that it's easy to get, I don't speak a word of Spanish. I mean, I don't know any of it. But I found that there's always somebody in the community that is going to accompany this person who's a fluent English speaker. My paralegals all were fluent Spanish speakers. I think it's just a lot of kids coming out of college today have many years of Spanish and can certainly read, if not orally translate. But the real benefit there is the community. These clients come to join a community. That community has been in place now for, in many places, 20 or even 30 years. And there are people there who want to help their members, and so they'll come to the lawyer's office after hours, they'll translate. Sometimes you got to work with the translator, because I had a situation where a client was accused of committing a crime in a bar, and it was a question, it wasn't a bar, actually it was at a house, and so there's a question of whether the client did it or somebody else did it. So I started asking questions. I said, what happened at the house? And so the translator and the client talked and talked and talked for like 10 minutes. And the translator looked at me and he said, he didn't do it. Need a little bit more than that. They're not professional translators. But to answer your specific question, I've never found translation to be an issue. Okay, so again, nuts and bolts. Day one, your client shows up to you at court and they've got a notice to appear. That's it right there. That's what it's going to look like. It's going to have the person's name, A number, address. Tell them that they have to appear at South Bell Street, Courtroom 4, Arlington, Virginia, at 10 a.m. on July 11th, 2013. It's an order issued by a court, signed by the court staff, on a date certain. That's your hearing date. When you show up, the first thing the judge is going to ask is for your entry of appearance form. And it has to be, I guess, things being what they are, you have to fill that out at the hearing. And it has to be on the green piece of paper, or otherwise they don't take it. So you put in your client's name and address, A number, I'm an attorney, Virginia, 32292, Maryland, no number. You sign it right there and date it. If you're going to do this, and this is a key logistical issue, if you're going to take these cases, you need to get an EOIR number. That's it's basically a bar number for immigration court. It's easy to do. You just register online. You put in your bar number for your state court and fill out a form, and you usually get an EOIR number in less than a day, and you come online. You got to have that for all the pleadings. This is the drill when you get into immigration court. Picture this: a room about half the size, so basically from this wall to there. You got a bench here. You got 5 rows, maybe even less than that, 5 rows of benches. In this room, you have court staff over there by computer, 2 tables, the government respondent, a translator off to the left, and then you've got 125 people in this room. And you've got the kids that are in the back, you've got the lawyers in the front, you've got, if it's winter, everybody's got coats on, and this is immigration court. Welcome to immigration court. The judge obviously wants to get through the initial master calendar hearing. He wants to get the lawyers out of there first. So what you do when you walk in the back, there's going to be a little podium that has a sign-up sheet. Sign that sign-up sheet, because that determines how long you're going to sit in immigration courts. A lot like traffic court. Then you go and you try to find a place for your client, try to find a place for you, make eye contact with the judge, let them know that you're there. Like in any other court, make eye contact with the court clerk. I was fortunate and I've got a good relationship with the court clerk up in Arlington. It certainly helps if you're pro bono. It certainly helps if you're professional in your attire, in your demeanor. Yeah, you know, talking frankly, a lot of the paid immigration bar, they show up, you know, dirty sport coat, khakis, you know, Reebok tennis shoes. It's not, the court staff appreciates it more if you show up dressed like you'd go into federal court, because it is a federal court. Case is called, the judge asks for appearances. You stand up. Bob Redmond, counsel for the pro bono, counsel for respondent. I would also always throw in the pro bono because it helps the government introduce themselves. The IJA, the immigration judge, asks for a plea to the NTA. NTA stands for Notice to Appear. That's the charging document. That's when they come across the border and get arrested, they will get processed, and the last thing they get is an NTA, Notice to Appear in court. And that will have two parts. One is the NTA, the other is the hearing notice, which I showed you before. So then the IJ asks for requested relief. We talked about that at the beginning. That's when you stand up and you say asylum, withholding, CAT. And then the judge sets the next hearing. Again, learning the hard way, you have to wait till the court clerk to issue the order. I would go to these master calendar hearings, plead the relief, walk out with my clients, head out to the lobby, and then the court clerk would be chasing me down afterwards, because it's a expedited system designed to be efficient, and one way they do that is that the court issues the order for the next hearing at the master calendar hearing. So you got to sit and wait for about 5 minutes after you get your hearing to get your next hearing. There are 4 allegations in the notice to appear. When you get your notice to appear, there's going to be 4 allegations. You are not a citizen of the United States. You crossed the border at McAllen, Texas. I forgot the other 2, but basically all of them are gimmies, and you got to admit to all of them. The only thing you might do is if it says you're a resident of El Salvador and it turns out they're a resident of Guatemala, you'd say, admit allegation 2, but change El Salvador to Guatemala. So this is all very rote. You're not going to fight about the 4 allegations. The requested relief, again, this is asylum, CAT withholding. You don't want to get fancy here. This is what you want. If you have an asylum application, it always helps to have already done it. So if you get your clients in advance of the hearing, it helps to get that 589 file prepared, get all your exhibits put together, have it typed up, have copies ready for the government, the judge, and the court clerk. So 4 copies, including one for yourself. Offer to put it in. What you may find is that the judge will say, I'm going to close this case, and you can apply through these, or actually say, would you like for me to admin close the case, and you could apply through the asylum office? And of course, that's a softball. The answer is, of course, yes, you want to do that. And so then you do that, and then the judge won't accept your pleading, will admin close the case, which means it's kind of dismissed without prejudice, and you can go file in the asylum office. If you can't do that, then you request a date for the individual hearing. Those are usually a half a day, 3-4 hours. In the Arlington Immigration Court, they're typically in the afternoon. Typically in these immigration courts, mornings are devoted to the master calendar hearing, which is the mass of humanity that comes through. Afternoons are devoted more to the substance, and so you'll get an afternoon hearing. And as I said to Matt earlier, that's probably going to be 3 to 4 years out. Maybe not 4 years, but 2 to 3 years out. And so, your client's ecstatic. You walk out, you're deemed a hero because they've got 2 more years to see how things shake out. And this is the documents I was just telling you about. The 4 allegations. You are not a citizen or a national of the United States. Yes. You are a native of El Salvador and a citizen of El Salvador. Yes, or maybe Guatemala. You entered the United States at or near Hidalgo, Texas on or about May 12, 2012. Yes, you may say, it was actually June 15th. You were not then admitted or paroled after inspection by an immigration officer. The answer is, of course, yes. So those are the 4 allegations. You admit all 4 allegations. So again, some additional tips. It's like traffic court. If you get there earlier, you get out earlier. Have your client well dressed. What I've found is that, especially with minor clients, it helps. It's very, very helpful to have them enrolled in school, or at least a GED. If it shows that they're getting educated, that's key. Announce a pro bono status when the court asks for appearances. Let me go back to this one. Some judges, and I can't criticize them, but some judges will quiz your client. They can ask questions of your client at the master calendar hearing. They'll say, you know, what do you do? Are you in school? No, I'm not in school. What do you do during the day? Because we're trying to find out if they're working, which if they're not in school, of course they're working, and they can't work. So, you know, they can get in big trouble at a master calendar hearing. So you need to vet your client beforehand, and, you know, like any good lawyer, you got to let them know you're going to be asked this question, and if the answer is I'm working, you know, painting houses with my uncle, that's not really the best answer. So you need to have the right answer and be honest, because they're under oath. I didn't mention this, but there's a translation service in the immigration court where they basically, your client will put on headphones, and there's a simultaneous translator that will repeat everything the judge says, and the client can hear it. And the judge will ask the client if they understand what he's saying, and he's got to respond. So prep your client on that as well. A lot of my clients have been around long enough to know English so they can respond in English. If they really can understand English, it's better to have them do that because it conveys to the judge that these folks are really committed to seeking the relief that they're asking for. As I mentioned before, announce pro bono status when the court asks for appearances, and wait for the clerk to hand you your order so you know when to show up next. Because you will not get anything in the mail from the court, ever. So this is not like state court or federal court. Your communications with the court are going to be in court. The court staff is talented but largely overwhelmed. They have thousands of cases. They are, you know, they're civil servants, so you know, they will do what's asked, but they're not going to go to great lengths. It's my experience. They're good people. I have good relationships with them, but you have to realize that they're civil servants at the end of the day. Last points. Immigration law is manageable. It's basically administrative. There's a book. There's a I forgot the name. It's Zurau, I think, or something like that. It's kind of the Bible for immigration lawyers. And it has literally everything in the world you need in there. It's about maybe 4 inches wide. I wouldn't buy it because if you're going to do iwi cases, that's a very thin slice of immigration law. I mean, the Zurau book is really for people who do, mostly it's for people who do marriage cases or cases like that. And it's just, that's just too much information. The book costs about $800 a year, and it's just not worth it. And what I think, frankly, what I've given you here with maybe a little bit more research into the circuit court case law is all you need to handle an immigration case. There's really nothing, in an iwi case, there's really not much more that you need. I didn't mention this before, but the immigration cases, kind of the appellate route, is if you lose at immigration court, you can appeal to the Board of Immigration of Appeals, or BIA. That's kind of it's an administrative 3-judge panel that's set up. To be candid, I'm not that impressed by them. I think they're mostly former IJ or former immigration judges, and they really are a rubber stamp of the immigration judge. When the judge rules against your client, they're not a rubber stamp if the judge rules in favor of your client. I mean, they're very, I won't say anti-immigrant, but they're pro-government in a big, big way. So BIA is not the place to expect a lot of relief. You lose it to BIA, you go to the Court of Appeals, whatever the Circuit Court of Appeals is in your region. There actually you get, I think, a better hearing depending on the circuit. Fourth Circuit, where I practice, is, I think, pretty even-handed. They've got some cases. I showed you Lizama versus Holder and Zelaya versus Holder. Very positive things for immigrants. I mean, some stuff to really grab on. Yeah. Seventh Circuit is bad. If you're in Chicago or the Midwest, you're in trouble. 11th Circuit, medium bad, not great, but that's what you got. So we have covered in an hour, less than an hour, everything you need to know. If you have any questions, I can answer any questions you may have, unless anybody has a question. Go ahead.
Probably a dumb question, but when you get to these individual hearings, is it adversarial in that the government is or is not?
Yeah, it is. It's definitely adversarial.
Like Social Security?
No.
Okay.
Yeah, that's a really good question. It's It is definitely adversarial, and you object to hearsay. I've been through a couple of these. You need to be on your toes, and the government is aggressive. They want to kick the person out, and there's no discovery. You can't ask for stuff ahead of time. You never know who they're going to call as a witness. They'll generally call your client, so expect him to testify. I had one of my clients came with his mom. Basically, she was there to support him. They called the mom, asked a bunch of questions of the mom. So, yeah, it's throwing elbows under the net. It's not. Don't expect any leniency from the government. They're prosecutors and they want to win, and that's the bottom line. The judges are, I think generally fair. They're judges, and if they want to stick it to your client, they'll do it in a way that's really hard to appeal on. So you got to build your record, and it's like anything else. But you do have a chance to make statements, and opening statements, closing statements, cross-examination, all that. It's well worth it. So any other question?
Yes, I'm not sure if my voice is going to be, but I had no voice for the past couple of days. You can see the words. First time I'm talking this morning.
Yeah.
So I apologize, I got in late, so these are like basic questions. How do you get clients in the first place?
We haven't talked about that. We had an intake clinic. The way we would get clients for this is if you send us an email, send me an email, send Matt an email, send the committee an email saying, I want to do this, we'll find an organization in your area that will get you clients. It's very easy to get clients. That's the easiest thing in the world. What I would recommend against is getting your name put on the list that's handed out at immigration court, because then you'll have way more clients than you'll ever be able to work. But there are clearinghouse organizations in every locality that are looking for lawyers. So if you say, where are you from? San Francisco. If you say I want to do a case, I'm in San Francisco, we can find out what the referral agency is, and then we'll say we have a lawyer who wants to do an EWI case, and let us know, and we'll put you in touch with them, and then you'll get a case that way.
And then prior attempts to do pro bono work have resulted in conflicts. The firm, just because, not necessarily actual conflicts, but potential conflicts of suing or making allegations against the school district or represent school district. So
Yeah.
have there been any conflict issues?
No, not for these cases, not the EWI cases. I run an internal conflict, but these folks, the clients they have no connection with the civil justice system in our firm. Yeah.
What about the prosecutorial discretion?
Yeah, that's a good point. I wish I'd talked about that more. The best route to relief right now is prosecutorial discretion, which, if you've been following the news, that's really the form of relief that has been institutionalized in Obama's DACA and DAPA policies. He's basically saying, if you meet these criterions, then I, as the chief executive, am giving you prosecutorial discretion. Prosecutorial discretion is a centuries-old doctrine in common law, and basically says the prosecutor has an ability to choose the cases they want to go forward on. And like anything else, there's some criterion that have developed over the years for immigration cases. Basically, no convictions, it helps to have U.S. citizen children, and what the relief you get is basically that the judge will dismiss, not the judge, the prosecution, the government will close the case. Without prejudice, they can reopen it, and you don't get any green card, you don't get any relief, you don't get a right to a work permit, and that's basically it. But it gets people out from under the threat of deportation, and they are very grateful for that. So, yeah, okay.
Can I speak just for
Yeah,
a minute?
sure.
Any other questions? I'm Matt Keenan. I'm the program chair of this newly formed subcommittee. We have a very small group here, so we might seize this opportunity to invite your thoughts and suggestions going forward, because we would like to have a place at the table at all of our upcoming meetings. And this was an idea. The immigration was something that we talked quite a bit about, but we're not necessarily limited to this. We wanted to have a signature program for the IADC. We wanted to have something we call our own that we could build on. I think 5 years from now, this room could be packed with people. So we want your comments and ideas and thoughts, because this is really the product of a very small subset of the membership. We want to grow it. We want to expand it. We think this is a great place to start. Bob's experience, I think think probably every one of our firms has some connection to immigration issues at some level. And we're certainly seeing it explode. And so we want your comments, your ideas. And so when you go home, think about this, talk to the people in your firm, perhaps do more pro bono. And we'd like to build on this. We'd like to do some webinars and some things to expand on some of these. And in a year or two, we can take another look at it. Maybe we need to not limit ourselves to this, but maybe go into other areas as well. I've talked to several national experts in immigration, and we've talked about maybe doing a presentation where we have them come up and have a panel presentation, kind of expand on what Bob's talking about. There's an abundance of people that have specialty that are clamoring for help from the larger firms to assist them in these cases. So there's a very acute need. It's only growing. A lot of people get phobic at the idea of doing something they've never done before. I've certainly seen it with all my partners, even areas less challenging than immigration. They're like, I only do this and that. So we have to overcome those, and I think we can. I mean, the beauty of this is, I think Bob mentioned this the very first call we had, this puts attorneys doing what they do best, which is advocating, being lawyers, litigating, on their feet, pushing the client's cause. That's really, I think, what separates, and we are the cream of the crop, I think it's fair to say, and we want to use those skills in the most advantageous way. So, you got a pen, you can write, well, all three of us, Bob, Craig, and I run the membership, but it's mkeenan@shb.com. I'm a Chicago Bacon. You can find me on the firm's website.
And I'm at McGuireWoods, so it's rredmond@McGuireWoods.com. And Craig, you're at Venable?
Yes, C.A. Thompson@venable.com.
Yeah.
What would you add to that, what I just said?
Yeah, absolutely. What Matt said is absolutely right. First off, this is a kickoff program. This immigration program is intended to jumpstart the Social Justice Pro Bono Committee. That's really what we're here for, is the Social Justice Pro Bono Committee. And as Matt said, in 5 years we could be doing all sorts of different things, and it may not be any immigration, who knows? But we thought about, we need to have something to start with. We just can't have a committee and say, what do you guys think? We needed to have something tangible, a program that could be imported by the members and they can sink their teeth into. And we thought and talked about it at length and thought that the immigration matters, the immigration court matters would be a great place to start, because it is in-court advocacy for an individual client that you can have a meaningful impact. As I indicated, the life or death or yes or no for relief for most of these folks is whether they get a lawyer. And most of the lawyers in this organization are here because they like to advocate. They've got a history of advocating. They're not afraid to take on tough challenges. That's the great thing about being a civil defense lawyer, is that in many ways the odds are stacked against you, and you go in and fight anyway. And that's really what I like best about immigration, is that it's hard. It's not easy, it's hard. It's simple, but it's hard, and it has a positive impact. So we're not here to say this is the only thing we're going to do. We're not here to say this is the best thing you can do. But we're here to say, if you want something to sink your teeth into off the bat, give us a call, send us an email. We're trying to make this as simple as possible, so you don't have to sign up for anything. If you're interested, send me an email. I'll find out a client near you. You can connect with them, and then the rest is yours. Run with it as you will. One thing I didn't mention, which is, I kind of hinted at it, these cases are not that onerous. There's some front-end work where you interview the client, you do the asylum application, you get the packet done. That's relatively a fair amount of work. And then there's a huge gap in time, and then you have the hearing. At the hearing, you've got to put your person on, you argue the case, it's a half-day hearing. That's the other end. In between the time, as long as your person stays out of trouble, you may not see them. I mean, I've had clients that I don't talk to for 2 years, but they stay in touch. One good thing about, if you've ever done pro bono, so a lot of times you run into people that, frankly, you lose touch with them, but I guarantee you, they will contact you when it comes up time for that hearing. It's on their mind day in and day out. So They're great for
And
clients.
it costs almost nothing. I mean, there's hardly any out-of-pocket expense with these cases, which
Absolutely.
which is important to I think, all of us, we're sensitive to that. So put your thinking caps on. My challenge to you is get engaged, talk to people in your firm who maybe do more pro bono than you, get their thoughts, and let's see where this goes. We've planted the seed.
Let me put in one last pitch for the committee. Thank you all for being here. This is a great way to get started. We have plenty of opportunities for you. We have plenty of slots. Vice chair slots are still wide open on our committee. So we have a call on the second Friday of every month. We'll kick back. We didn't do it this month because we're having this meeting. But in March, we're going to have second Friday at, I think it's 4:30 Eastern. And then subtract back from that. But that's when we talk. We have I'll circulate an agenda ahead of time. Just dial in through the IADC, and we'd love to have you. And we have an opportunity to talk a little bit more about other programs that we're going to do in the future and just how you like it. So, yes.
So that call is not run through the IADC. Does that go to everybody?
Yes.
Let you know that you want to.
I think you need to let me and/or Melissa Mizell. She's our liaison. So let Melissa know. She'll put you on the calendar list, and I do send out an agenda.
We should probably circulate something now to get email addresses so we can give that to them.
That would be a smart thing to do. Thank you. Yeah, I'll just, actually, Craig, if you want to, thank you very much. You just put your name on there, and we'll get that to Melissa, and then we'll get everybody on the routing list. But yeah.
How much easier is this for you because you've got, the court is where you are? In other words, I want to-
Sort of.
Yeah.
Yeah.
Go Charlotte, wherever you want.
Yeah, Arlington's a good 2 hours from me, and DC traffic, so it's not that easy. But you're only going to immigration court twice, and it's not easy, but it's not. You're not going up there. I used to go up a lot when I had at one point I had 50 cases, and that was a lot of travel. But one other thing is that immigration court will work with you on hearings. Like if for whatever reason, if you wind up with 4 clients, you can go to the court and say, I've got 3 people coming in on April 16th, 2017. Can I have my hearing set for that? And the court will work with you. They're very, very solicitous of pro bono lawyers. It's remarkable, at least in the Arlington Immigration Court. So, well, thank you all very much. I appreciate it. Thanks.